This is my 5th video in the video installment series responding to Trump being so angry that the Smithsonian Museum is actually having exhibits and teaching slavery for what it was, the horrible institution based on white supremacy. And in order to combat this revisionist history of turning slavery into some benevolent institution and the resurgence of neo-Confederates and Confederate worship, I've committed myself on this channel to exposing the real horrors of the antebellum slaveocracy by looking directly at the court decisions and the words directly from the mouths of the justices and the jurists of the slaveholding antebellum South. Now, excuse me today because I have been under the weather. I've lost my voice a little bit, but it's been a few days since I've made a video, and while I was convalescing, I had a temperature and a fever. I was sitting around the last few days. I was again going through an inquiry into the laws of Negro slavery in the United States by Thomas R.R. Cobb, and I wanted to discuss something that is going to be very difficult to listen to. So first, before I get into it, when many people come to this channel and attack the sources that I use, especially Thomas Cobb's work, remember that Thomas Cobb was one of the most famous jurists in the antebellum South. He was an attorney, he was from Georgia, and as I've said in many previous videos, he became, to the Confederates, affectionately known as the James Madison of the Confederacy. That is how instrumental he was in the drafting of the Confederate Constitution, which forever enshrined the institution of African slavery into that new and failed country, and of course, codified white supremacy. So when we look at this work, yes, it's the writing of him, but he cites all relevant court cases from the antebellum slaveholding South. And also, attorneys use works like this all the time. If you were a property attorney, you can get a corpus of property law in the state in which you work, and you can use that and reference that when you're practicing law concerning property. The same was true in the antebellum South. If an attorney had a case dealing with an enslaved person or an issue with a slave, they would often go to this book to find the resources they needed to be able to defend, to articulate their points, or to make their case. This work was so influential that I've even told you in previous videos, the Alabama Supreme Court even cited from it at one point. Now, they disagreed with something he wrote in here, but they thought this book was so influential that they needed to make their point that they thought he was wrong because of how many people looked up to this as the ultimate resource for slave laws and slave codes in the antebellum South. So that's why it's important to understand what this work actually is. Now, today we're going to discuss unwanted or unconsensual sexual relationships between enslavers and enslaved. So again, another trigger warning. If that's something that bothers you, I would pause the video and I would really consider whether or not you want to go through with watching this, because this is going to be horrific and terrifying. And again, I only bring these cases up to combat neo-Confederates, the revisionist historians, all of this that we see today, and Trump's anger that how dare the Smithsonian actually teach American history. And when it comes to slavery, American history is very bleak, it's very bad, it's very evil. And we have to confront that. So today, before I get into what we're going to discuss, I want you to remember and go back and watch previous videos. We've talked about the Somerset decision. The Somerset decision happened before the United States became a country, happened in England, and the long and short of it is, the judge, Lord Mansfield of that case, he made the claim that slavery is so odious, it goes so against human nature, that it can only exist if positive law is on the books. Meaning, there has to be a law that says you can have slaves in order for there to be slavery. If there's no law on the books, then because slavery goes against the law of nature, it cannot exist. Well, the slaveholding states, what will become the antebellum South and eventually the Confederacy, they didn't agree with this, so they made the argument that slavery was the natural condition of the African race, of Africans and people of African descent. So, not the topic of this video, but when many people claim that antebellum slavery in the United States wasn't racial or wasn't based on white supremacy, right there from the beginning, they're proven wrong. Because from its inception, as it was codified in what would become the United States and eventually the slaveholding states of the South and the Confederacy, they believed you didn't need a law to support slavery because slavery was the natural condition of black people. Only black people. when it came to their relationship with white people. So go back and watch previous videos on that. I want to focus on the topic at hand today. Now, the interesting thing was that while the jurists in the slaveholding states believed you didn't need positive law to have slavery, you did need positive law to limit the power and the authority of the masters over the slaves. Without any positive law protecting an enslaved person, then a master could, in theory, according to these jurists, do whatever they wanted to the slave with one exception. So let's pick up in chapter 4 of Thomas R. Cobb's An Inquiry into the Laws of Negro Slavery and see what he says about this. He says, the condition of these slaves in their native country having been one of absolute slavery, including the power over life, such would be their condition in the country to which they were removed, except so far as the same may be modified by the existing laws of their new domicile and such subsequent legislative enactments as may have been made for their benefit. So what he's saying is because Africans in Africa being sold to whites were absolute slaves, meaning their owners in Africa could kill them if they wanted to, then their condition remains the same when they're transported to their new domicile and to their new owner, their new enslaver. However, that's only limited by legislative enactments. Now, he does say the law of nature, because remember, he said, and again, go back and watch previous videos, I don't want to relitigate it here, but he claimed that the slavery was the natural condition of people of African descent because it bettered their condition. And anything that betters the condition of someone else isn't contrary to the law of nature. So he does say, the law of nature denying the power over life and limb being part of the law of every civilized state, such power never existed in any of the United States, although it required municipal law to prescribe the punishment for such offenses. So what he's saying is, because the law of nature says we have to benefit the individual or the group that we're doing something to, even though the law doesn't say you can't kill or maim an enslaved person, we say the law of nature forbids a master from doing that here. However, while it may forbid him from doing it, there is no punishment for that unless the legislative branch of the state comes in and makes a punishment for it. So again, you're seeing that they advocated for the absolute power, the absolute authority of the master, except where it crossed over into their argument of the law of nature being better for black people to be slaves. So therefore, you couldn't just arbitrarily kill or maim an enslaved person. It says, many subsequent legislative enactments have been made regulating the power of the master and protecting giving rights to the slave. Having none prior to these enactments, to the municipal law we look for all of his rights. So what Thomas Cobb is saying is that unless there is a municipal law, unless there is an actual law that says that this is a protection for the slave and this limits the power of the master, then a master has the power to do A, B, C, or D, unless the legislative branch, the legislature of that state, restricts the master's right. Let's continue. The protection of the person of the slave depending so completely upon statute law, it becomes a question of importance what words in a statute would extend to this class of individuals. Generally, it would seem that an act of the legislature would operate upon every person in the limits of the state, both natural and artificial. So he's saying now, here's an argument that was brought up. Well, it says don't murder, don't steal, don't rape, etc. However, does that apply to an enslaved person? He's going to say no. He's going to say the legislature has to make specific laws to limit the power of a master and to protect an enslaved person. He continues, experience has proved what theory could have demonstrated, that masters and slaves cannot be governed by the same laws. So different in position, in rights, in duties, they cannot be the subjects of a common system of laws. Hence the conclusion that statutory enactments never extended to or include the slave, neither protect nor to render him responsible unless specifically named or included by necessary implication. So he's saying that all the laws you see on the books do not protect enslaved people and do not relieve or limit or temper the power of the master unless the legislature specifically says it in that legislation. So it may say that you cannot murder in the state of Virginia. However, unless it says that you cannot murder an enslaved person in the state of Virginia, then a master would be allowed to do so, only tempered in that situation by the law of nature, which Thomas Cobb says since murdering doesn't benefit the person, therefore it would be a protected right. However, if the legislature did not enact any sort of punishment for the murder of a slave, it would go unpunished. So this is horrific. But now, murder is one of those things where, because Thomas Cobb says the law of nature would prevent the murder of a slave, let's look at the disturbing part here. Let's look at another crime. Unconsensual sexual relationships. And even though YouTube will probably never monetize any of these videos because of how horrific they are, I'm just going to say it. We're going to discuss rape, right? Thomas Cobb says, the law, by recognizing the existence of the slave as a person, thereby confers no rights or privileges except such as are necessary to protect that existence. That goes back to the not murdering or maiming an enslaved person. However, the legislature would still also have to enact a punishment for that. But that is the only right they're guaranteed by the law of nature, according to Thomas Cobb and other antebellum slaveholding jurists. Hence, the penalties for rape would not and should not, by such implication, be made to extend to carnal forcible knowledge of a slave. The offense not affecting the existence of the slave, and that existence being the extent of the right which the implication of the law grants. So that's kind of disturbing. What he's saying is that since the law, natural law, the anything not written, only protects the existence of the slave, raping a slave, since that doesn't do anything to their existence, it doesn't kill them, it doesn't maim them, therefore, it is not something that would ever be naturally protected. There must be a legislative enactment to prevent or to protect a slave from the vicious crime of rape. Gets worse. He goes on, it is a matter worthy the consideration of legislators, whether the offense of rape committed upon a female slave should not be indictable. So what Thomas Cobb is saying is, you know what, the legislature should maybe pick this up and decide whether or not raping a slave is a crime and carries a penalty for a white person who does it. But he continues, and whether when committed by the master, there should not be superated the sale of the slave to some other master. So he's saying, and if a master does it, maybe the punishment should be that that enslaved person be sold to someone else, right? Because that would obviously solve the problem. This is the disturbing part. The occurrence of such an offense is almost unheard of, and the known lasciviousness of the Negro renders the possibility of its occurrence very remote. See, if Thomas Cobb would have just left it at, it's a good idea for the legislature to try and come up with legislation that protects slaves against rape, that would be one thing. But then he goes on to say, you know what? It doesn't even really matter because the rape of a slave is so rare, it's so uncommon, because enslaved people are naturally lustful animals, and anytime that a master or a Caucasian has a relationship with a slave, it's not rape because they wanted it. That's what it's saying. That's lasciviousness. That's what it's saying. That these Africans and people of African descent are just animals, and they're subject to their lust. So therefore, if a master has a relationship with a slave, 9 times out of 10, according to Cobb, it's not rape. It's because the enslaved person wanted it. So therefore, legislatures, you should really think twice if you are going to consider it. Also remember the nature of black people and people of African descent is that they really wanted it. So maybe you should take that into account if you decide to come up with any sort of law to punish the rape, the forcible rape of an enslaved person by their master or by any other Caucasian individual. So when Trump says, when Trump shows on his X or tweet or whatever it is, how upset he is that the Smithsonian is showing how bad slavery was, let's be clear. Slavery was worse. It was a lot worse. And it was based on white supremacy. It was codified white supremacy. And when you just read the words directly from the mouths on paper of these jurists and of these antebellum courts and the justices that wrote these opinions, you really get into window into how horrific a system it actually was. So as always, remember to like, subscribe, share, and I'll see you for the next lesson.